There we go.
Perfect. All right, and we are live.
All right, hello everyone and good evening. Welcome to tonight's Title IX Town Hall event. We're really excited to have everyone. Thank you to everyone viewing at home. My name is Abby Wolf and I'm the Student Government Director of University Policy.
We are live. Sorry.
And then this is Meredith.
I am Student Government's Director of Gender Relations. We're so happy to have all of you joining us to talk about this important topic. And we're grateful to all the panelists for joining us from across the Tri-Campus community. And in particular, we'd like to welcome Amber Monroe, the Program Manager and Deputy Title IX Coordinator at Notre Dame, Mike Colonna and Pat Cassidy, who are Senior Equity Specialists in the Office of Institutional Equity at Notre Dame, Liz Colston, who is the Bells Against Violence Coordinator at St. Mary's, Nicole Hunt, who's the Title IX Coordinator at St. Mary's, and Andrew Polanecki, who is the Dean and Vice President of Student Life at Holy Cross.
Again, thank you all for being here with us tonight. Just to give you an idea of how this event is going to go, we're going to begin with kind of an overview presentation about Title IX and other sex-based misconduct procedures at each of the three universities, because this is a tri-campus event, from our panelists, and offer clarification to the new federal changes to Title IX and how that has impacted our campus communities, as well as some general insight on reporting. And then next, we'll be asking the panelists some questions. We got some questions submitted before the event. As a reminder, there is the bit.ly link in our YouTube live description that you can still submit questions during the event as well.
And then finally, a content warning. We recognize that this topic is sensitive, and we want to ensure that viewers have resources available if you're feeling emotionally distressed at any point during the event. Resources and phone numbers for support are listed in the YouTube description. And in addition, please note that any questions or comments submitted during the live Q&A portion of the event will not be considered a formal avenue to report an instance of sexual assault or harassment. Any information you share in your question will not be investigated by any of the universities. And if you do wish to formally report an incident or receive support, please see the resources listed in the YouTube description.
All right, with all of that said, now we will turn it over to Amber, Mike, and Pat to begin our presentation to give an overview of Title IX.
Thank you, everyone. Sorry, first of all, I just wanted to thank Meredith and Abby for coordinating this for us to be able to share information with you. And I apologize that I'm sharing my screen, and so I couldn't see that Mike was getting ready to chat as well. So I will just turn it back over to him. Mike, thank you.
Thanks, Amber. Thanks, everyone, for being here and for having us, and for just being here to discuss a very important topic that's near and dear to kind of all of our hearts, and that's something that we all work on. That's the Title IX. Like I said, my name is Mike. I'm a senior equity specialist at Notre Dame. What my job is to do is, when there are allegations of sexual or discriminatory harassment, I along with Pat and several other individuals from our office, go and ask people questions, essentially to try and figure out what happened. And so the framework from which we have to do our job, or the rules, a lot of the rules as to how we have to do our job, come from Title IX, come from federal regulation. And so these new Title IX regulations were a significant change from the previous ones. And so we'd like to take you through kind of the highlights as to what the new Title IX regulations are, and how we have dealt with them in our jobs. So this is going to be specific to Notre Dame's policies and procedures, at least the slides are. Representatives from Holy Cross College and St. Mary's College will jump in and explain maybe when things are different or when they don't apply, but don't take this as kind of the gospel for all three campuses, because it's not. It's just, this is essentially how Notre Dame specifically operates. There's no right or wrong in terms of who operates how, but this is kind of just a disclaimer. And with that, if I can get the next slide. Thank you, Amber. So the new regulations, there's several kind of key things that take away, that have altered the way that not only Notre Dame and Holy Cross and St. Mary's has responded to sexual harassment, but all colleges. And it kind of falls into two broad categories in regards to the changes. The first is the scope of Title IX, in terms of what Title IX addresses, what can universities address under the Title IX regulations. And then once that's chosen, in regards to what is going to be addressed by universities under the Title IX banner, then it's how do the universities deal with that type of thing? What are the procedures are in place? What are the steps? What are the mechanisms that each university has to go through in order to more fully address a Title IX situation? So obviously the scope of Title IX, there's implications to it being changed. For Notre Dame, the most important thing is that from our policy is that while the new regulations change the scope of institutions' Title IX policies in several important ways, the university may still address actions that fall outside these new limits, however, through non-Title IX policies. And that's a really important distinction to understand, is that even if we hear of conduct or we begin an investigation into conduct that may not be under the Title IX definitions as allowed by federal regulations, we can still treat or we can still address that situation using the same type of procedures that it would normally have gone through if it was regulatory Title IX issue. The university has modified its process for addressing concerns of sexual harassment by employees, and as such, concerns must be addressed through the new regulations' formal procedure requirements. The university also developed a process to address student conduct concerns that do not fit within the narrow definition of sexual harassment. So Notre Dame takes great care in identifying each situation and trying to work with it as much as it can. So that's why there are different procedures in regards to whether the respondent is a student or whether the respondent is faculty or whether the respondent is staff. The procedures are, it all depends on that, and they can be unique to each scenario that the Office of Institutional Equity receives. From a student's perspective, the most critical kind of changes under Title IX is first and foremost, a formal complaint must be filed by either the complainant or the Title IX coordinator. Third parties cannot file a formal complaint on someone's behalf. So that just kind of means what it says. If a person is the subject of Title IX, of conduct that falls under Title IX, they're the only individual that can file the formal complaint outside of the Title IX coordinator in our office. So if you're a concerned friend or a family member or a teacher, anything along those lines, if you're not the person, you cannot be filing a formal complaint on behalf of that person. The next critical difference under the new Title IX regulations is that all evidence and testimony is subject to cross-examination, including anything provided by the complainant, respondent, and/or witnesses. So the importance to that is that with the new Title IX regulations, if there is evidence that cannot be subject to cross-examination, then it's not going to be allowed in. It's not going to be heard by the decision maker. So that could include a witness who initially speaks out to either the university, the investigator initially during the initial portions of the investigation, but when it comes time to the hearing or the panel and who are making the decision as to whether or not there is a violation of Title IX, if that person's not available to be cross-examined by the advisor of the respondent and to be questioned by the advisor of the complainant, that information or that evidence that stems from that individual is not going to be allowed in. It's going to be as if that person was never in existence and they never saw or heard or said whatever we learned through the investigation. And another critical difference to students that students should understand is that the use of advisor and/or resource coordinator is still limited to having only one person at a time. The resource coordinator is more specifically for Notre Dame resources. So the resource coordinator is someone who is well-versed and has a wealth of knowledge in regards to what specific options or resources can Notre Dame provide to the individual, whether it's a complainant or a respondent. And these are resources to help the individual not only through the process itself, but also to deal with kind of life outside of the process, whether it's counseling, mental health assistance, those types of things where a person who goes through the procedure, whether it's a complainant or respondent, are going through significant mental stress. And so the resource coordinator is there to help that person navigate the process, to understand how it works, and also for assistance in dealing with it. The advisor, the resource coordinator is one position, the advisor is separate. The advisor is primarily for the process and the hearing. The new Title IX regulations require that an advisor be appointed, or that the individual have an advisor for the hearing. And so based upon that, the person can choose anyone they'd like as their advisor. However, it's strongly recommended to not use faculty, rector, a resource coordinator, or other university employees. The suggestion that, or the recommendation, is to get someone who is well versed in these types of procedures and policies, and someone who's not connected to the university by way of being a faculty member, rector, resource coordinator, or other university employee.
And Mike, before we move on to the next slide, I did want to also clarify on that first bullet point where third parties cannot file a formal complaint. A formal complaint is actually what moves something forward into an investigatory stage. That doesn't mean that we can't receive third-party complaints of harm. And so I would still then outreach to somebody to say, you know, a third party reported that you may have experienced something. And so I invite you to come talk to us about your options. And then that complainant would then have to file a formal complaint. So I wanted to make that distinction that we can still receive reports that harm has occurred to somebody, but in order to move that into some kind of investigation under a formal Title IX procedure, only the complainant or the Title IX coordinator are the people that can do that. So wanted to make that distinction.
And it's a good thing that Amber is paying attention to what I say, because she's going to be doing a lot more of correcting me along the way. So I apologize for not being as clear as Amber is, because that's impossible. But that's an excellent point. If you see something, you should still say something to our office. It just ultimately depends on who saw it, and who is saying something depends on what process or how that process goes along. It's something that we as the office still want to address, obviously. So the main points of impact for the Title IX, new Title IX regulations is, the first of which is that the definition of regulatory Title IX, which is what, I'll start over. The definition of regulatory Title IX has narrowed. And that means that there are certain things that colleges are only obligated to respond to reports of sexual harassment that occurred off campus if the location is in use by an officially recognized student or institution organization. So the only time that Notre Dame has to respond to a report of sexual harassment that occurred off campus is if that off-campus location was in use by an officially recognized student or Notre Dame organization. But the really important part of that is the bullet point underneath that top bullet point, is that the university will still address all concerning behavior. So just because it doesn't fall under the regulatory Title IX definition, the Notre Dame policies and procedures allow for Notre Dame to still treat that non-regulatory sexual harassment under the same procedures that regulatory sexual harassment would normally go under and go through. So there's still the same, you're still going through the same processes. There's still the same accumulation of evidence. There's still the same review of evidence. There's still the same going through, having a finder of fact make a determination as to whether or not there's a policy violation. It's just really nuanced and complex in regards to what the name of the process you go through, even though the process itself is essentially the same. The definition of sexual harassment is also more narrow. The definition of sexual harassment is that any unwelcome conduct that a reasonable person would find so severe, pervasive, and objectively offensive that it denies a person equal educational access. And so the way it used to be was that the unwelcome conduct needed to be severe, pervasive, or objectively offensive to a reasonable person. And now it has to be all three. So again, it's limiting what could technically be identified as regulatory sexual harassment, but the Notre Dame policy allows something that even if the conduct was severe, but not necessarily pervasive or objectively offensive, it can be still dealt with under the same procedures. Also, colleges are not obligated to handle complaints of sexual harassment that occur outside the US. So the reason why that, I guess, applies or is important to Notre Dame is Notre Dame has a lot of travel abroad opportunities and travel abroad educational opportunities. So under Title IX regulations, Notre Dame is not obligated to handle complaints of sexual harassment that occurs outside the US. However, again, our procedures, Notre Dame's procedures, still allow Notre Dame and the Office of Institutional Equity to handle it under if it's the same procedure. The next bullet point in regards to the main points of impact is that the regulatory complainants must file a formal complaint and participate in a hearing. again, that goes back to what myself and was kind of stumbling through, and then Amber clarified for all of us, and that if you're the individual who's actually going through or receiving the subject behavior, you're the person who ultimately must file the formal complaint, or the Title IX coordinator. A witness to that conduct could not file the official formal complaint, which is what kicks off the actual investigation. Obviously, we still encourage and we want the individuals who witness this type of behavior to make a report, to contact the Office of Institutional Equity, to contact us, to let us know that this is occurring so that we can attempt to look into it. However, they cannot kick off the investigatory portion of the process. And finally, regulatory alternative resolution can be used, but a formal complaint must still be filed. So the formal complaint still needs to be filed, and at any point in time during the process, it can veer off to where there's using alternative resolution as opposed to going through the actual procedural process for an investigation. The only exception to that is that alternative resolution is not allowed for situations where the respondent is faculty and staff and the complainant is student. Again, that's taking into account how Notre Dame is cognizant of the fact that different groups of individuals need different resources or should be treated a bit differently. And that's a really good example of if the respondent is a faculty or staff member, because there's type of a power and control situation or that's available, or that the opportunity to be abused, and the complainant is a student, alternative resolution will not be allowed. So the considerations in student cases, when we're addressing student concerns about other violations such as parietals or alcohol, when issues when issues of sexual harassment come up, that's something that will be looked into. However, the inverse is actually not true. If the Office of Institutional Equity, in the course of completing its investigation into a sexual harassment matter or behavior, when myself or people like Patrick or any one of our other colleagues are asking people questions in regards to what happened in regards to a sexual harassment behavior or conduct, we grant essentially immunity to individuals as to whether if they violated parietals or if they admit to drinking even though they're underage, or admit to having a fake ID even though they're underage. And the reason behind that is we want people to be really honest, and we want people to come forth and give us as much information as they possibly can. And one of the ways to do that is to say, you know, if there's a behavior that they maybe could get in trouble for, such as parietals or alcohol, they're not going to get in trouble for it. And oftentimes the reason why we're asking questions in regards to alcohol abuse or drug abuse is because we want to attempt to figure out the degree of memory that the individual has at the time. I know my memory is horrible to begin with, but if I'm sober, my memory is much better as compared to 4 or 5 beers. So that's also why we give individuals immunity in that, because we want to see what their memory was like. There's also the incapacitation for intoxication. Some believe that one cannot have any alcohol and give consent. There's also the understanding how each person defines a term or phrase. Terms or phrases can mean different things to different people and different subcultures. With each generation, there's new slang that everyone tries to keep up with. So we have to be very cognizant of that fact as investigators, to if people are using phrases that we're not entirely sure about, that's something that we want to ask a question to clarify, to make sure that everyone's on the same page in regards to what is happening or what's being talked about. Usually cases involve parties from the same friend group. The Office of Institutional Equity cannot impose a gag order. However, every person that we talk to, we ask to keep the conversation confidential. That means that the members from Office of Institutional Equity will not be sharing the fact that we've spoken with these people, let alone what they've spoken about. And we ask that they do the same thing, that they do not go and share the fact that they've spoken to us or that what they've said. There's a lot of reasons behind that, one of which is that it helps our investigation. When we ask people questions, we want to know what that person, individual's perspective was. We don't want it tainted by other people. But ultimately, we don't have the enforcement to put a gag order over people. So if sometimes people talk, there's nothing we can really do about it. But ultimately, I think any investigation is better when kind of everyone is kept separate and offers their own perspective, because that's all we want to know is what someone themselves remember hearing or seeing. We don't want to find out what someone thinks they heard or saw based upon what someone else said. And then there's also the hookup culture's impact on perception. With that, a lot of the cases that we see stem from parties, alcohol consumption, essentially, parts of the hookup culture itself. And so, and based upon that, we have to keep that in mind. We also have to remember that when these events are occurring, that also means there's a lot more witnesses that we'll have to be looking into and we'll have to be speaking with. And with that, you guys no longer have to listen to me drone on. I'm going to hand you off to my much more capable partner, Patrick, who's going to take you guys through the Title IX procedures.
Well, I don't know about that introduction, but thanks, Mike, for kind of getting us started here. Before I continue on with the slides, I want to make sure that nobody from Holy Cross or St. Mary's, and we kind of breezed through there, but anything, Andrew, Nicole, Liz, you want to add at this point?
No, just on the end at Holy Cross College, I mean, we really are ultimately kind of, we're implementing obviously the same, federal directives here, and our process and procedure really would match up and look the same. And I'm glad that you guys kind of emphasize that's always a continuing question about when other things are tied into investigation or questions about that come up, like alcohol and parietals. And we're the same here at on our campus. You kind of have that, the amnesty, the immunity from kind of, follow up, because again, we want those cases to be shared. We want students to understand that, we want to, unpack the truth and discover those stories so that we can do the best to keep our campus safe. So I'm glad that you guys highlighted that. Thanks.
Yeah, same thing over here with St. Mary's. Like Andrew said perfectly, we're all kind of working with the regulations in the same way. I also appreciated that you really highlighted that even though the scope has narrowed, we're still able to continue on the process of some of those things that wouldn't necessarily fall into the new scope, because that definitely holds true here at St. Mary's.
Awesome. Thanks, Andrew. Thanks, Nicole. And really just to reiterate what Amber and Mike said at the front, thanks to Meredith and Abby for inviting us here. Obviously just a critically important issue. So it's great to have the opportunity to talk through some of this stuff. And honestly, it's really complicated. We don't mean to make it obtuse or, it's a long procedure document. We get that it's complicated. It's like that for a reason. In a lot of ways, it has to be based on federal regulations. And we want to make it as clear as possible. So to have an opportunity like this where we can kind of talk through things, try to put it in, very simple and clear terms, it's great. And so I know I'm grateful for the opportunity, and just thanks again to Meredith and Abby for setting it up. So what I'm going to do is talk through at a high level Notre Dame's Title IX procedures. They're found, we got this nifty link in here, they're found on the Office of Institutional Equity's website. I encourage you to read it. A lot of this is going to make sense in context. I'm going to try to contextualize it as we walk through, but we tried to write it in a way that's very clear and that is accessible to non-lawyers and basically everybody in our campus community. So I'll do my best to explain it, but I would encourage you, if you have questions, especially if there are questions that aren't answered in this town hall, dive in and read the policy and procedure, because we've tried our best to make it clear. So the 2 bullet points here, they note that the new regulations, the ones that came out last summer, are heavily focused on elements of due process, which include notice of allegations, access to evidence. Mike referenced this cross-examination idea, referred to here as the right to confront an opposing party and witnesses, and the right to appeal. So there's due process elements that were really stressed by the prior Department of Education. And even though there's a new Department of Education, we really don't expect a lot of those elements to go away. Maybe relaxed cross-examination requirements down the road, but for now, the current Department of Education regulations are still binding federal law. They still apply to Notre Dame. They still apply to St. Mary's. They still apply to Holy Cross, as well as every other college across the United States. And so we have to deal with them. And honestly, even if the regulations shift a little bit, this is the trend that courts are going. So the policies and the way that universities have to deal with these issues, we have to pay attention to ideas of procedural fairness or due process. And that kind of gets to the second point there too, that the regulations mandate that formal complaints, this kind of term of art, a formal complaint of sexual harassment, be resolved through an elaborate process. And that's what I'm going to walk through in the next couple of slides. So Amber, if you wouldn't mind clicking ahead. So at a high level, this is what happens again in Notre Dame's process. Once a complaint is received and a formal complaint is filed, again, either by the complainant, him or herself, or by Notre Dame's Title IX coordinator, our office, typically, usually Amber, is going to outreach to the complainant, provide interim measures, provide supportive measures, and our office will conduct what's called an initial assessment. We'll gather the facts. We'll understand, is the conduct that's being alleged, does it even meet the definition of sexual harassment? Do we need to be in these heightened regulatory procedures, or can we go to the other non-regulatory procedures, which are just a little less formalistic? So that's what's kind of in that initial assessment phase. And then after the initial assessment, we pick the process. And so kind of for purposes of our discussion, we want to focus here on Title IX. So let's assume that Amber meets with the complainant. We get the basic facts of what that person says happened, and we say, okay, well, if that's all true, we're in this new Title IX regulatory sexual harassment world, and we need to follow the regulatory procedures. So that's where we'll go next. This is an overview, and I want to talk through each of these phases in a little more detail, but I think there's confusion out there, like Title IX framework, it's just a mess. No one understands. It's a black box. What happens when a formal complaint is filed? Well, at a high level, these are the 6 separate phases. First, you get the formal complaint. Then you have a formal investigation or alternative resolution. Mike made this point earlier. It's crucial that for either of those 2 options, you need a formal complaint filed before alternative resolution is even on the table, or a formal investigation. If we're in that sexual harassment realm, that regulatory realm, you need the formal complaint. So let's say formal complaint, we decide it's appropriate for a formal investigation. Next phase is the notice of investigation. This is a document that comes out from the Office of Institutional Equity. It'll be signed by the Title IX coordinator, Aaron Oliver, and it'll say, this is the conduct that's been alleged. These are the procedures. These are the rights that both parties have, and both parties are going to have equal rights throughout the whole process. Things like right to an attorney, right to an advisor, right to appeals, the presumption of innocence. It'll state the standard of proof, and I'll talk about all this in a little more detail in a minute. But that's all in the notice of investigation. It kind of overviews the process and gives both parties, the complainant and the respondent, a heads up about what's coming. And particularly for the respondent, it gives that person an idea of what conduct is being alleged, what policies that they were alleged to have violated. So after the notice of investigation, we move into the investigation. And let me just pause there and go a little more slowly into the investigation. So Amber, if you wouldn't mind actually skipping ahead, I think, to the next slide, it blows out the investigation, and then we'll probably go back to that other slide and talk about the last couple phases in a minute. But the investigation kind of has its own separate step, 6-step process, we'll say. So in the investigation, an investigator, an independent investigator whose job is not to gather evidence to prosecute a respondent or gather evidence to defend a respondent and make sure that that person is found not responsible for a policy violation, the investigator's job is to ask questions, to get information from all of the witnesses. And so that's what the investigator's first step is going to be. Well, what are the witnesses that we want to talk to? Well, set up those meetings, talk to those people. Oftentimes there will be text messages or security camera footage or emails that kind of provide corroboration to the accounts that individual witnesses give. And all of that is compiled. It honestly usually takes at least a couple of weeks because there are a number of witnesses. Each witness, assuming students are involved, there are class schedules. If staff or faculty are involved, there are work schedules to coordinate around. But we set up those meetings, we meet with witnesses, we meet with the parties, and type up summaries of those meetings. Phase 2 is the evidence review. So at the conclusion of the information gathering phase of the investigation, the investigators will compile all of that, all the interviews, summaries, all of the text messages, all of the emails, and provide that to both parties and their advisors. So it's a limited group that gets to review that information. It's just the parties and their advisors. It's not all other witnesses or anything like that. But both parties are going to be able to look at everything that has been gathered by the university, everything that's relevant and directly related to the allegations. That goes to the parties, either hard copy or electronic. In our current Zoom world of Zoom meetings, we're currently doing this electronically. But back in the day, we would provide this information in our office, and both parties would have an opportunity to come in with their advisors and review the evidence. The parties have 10 days to do this. And in those 10 days, they're also afforded an opportunity to provide written feedback on the evidence. So things they could provide are like, well, we noticed you didn't ask this witness these questions. We think it would be relevant to get that information. Both parties have the opportunity to, provide comments on the evidence, identify additional witnesses to interview, ask the investigators to bring up additional issues with witnesses that already were interviewed. And after that 10-day process, the investigation is kind of reopened. And as appropriate, the investigators are going to go back out and follow up where both parties potentially had asked questions. After that second phase of investigation work, the investigators provide an investigative report. What this report contains is all relevant information, again, kind of compiled. At this point, it's compiled. Before it was just, here's the file, you guys can take a look at it. The parties can take a look at it. Now, all of that evidence is going to be clearly organized, categorized, usually chronologically. It'll have both parties, all the witnesses' perspective on events, and it'll explain that other documentary evidence, the text messages, the emails, the security camera footage, things like that. And it organizes all of that clearly. That investigative report then goes back to the parties. With their advisors, they each have 10 days, again, to review that, carefully consider it. Well, what questions do we want to ask at the hearing? What issues are open? After the investigative report goes to the parties, it also goes to the hearing board. Now, the hearing board is the entity that ultimately decides what happens. I kind of mentioned how the investigators are neutral parties. They don't have a stake in the outcome. They're not the decision makers. They're not the attorneys for either party. They're neutral. Well, the hearing board is also neutral, but they're vested with the authority to decide, well, what actually happened here? And then if a policy was violated, what sanctions are we going to impose? So the hearing board, and at this point, Amber, if you wouldn't mind going back to the other side, because now we're kind of back in the wider process, if you will. So here we're in stage 5, the blue row in the middle. So we're in the hearing. The hearing board is composed of different members based on the identity of the respondent. So in a student case where a student is the respondent, there's going to be an outside hearing officer who's in charge with kind of ruling on evidentiary considerations, essentially like running the mini trial that is the hearing. That's an outside attorney who's an experienced litigator, again, a neutral party who's in charge of running the logistics of the hearing. And in addition to that person, there'll be 2 additional members from the Student Hearing Board Committee. And that committee is chosen by the Vice President of Student Affairs in consultation with the Vice President of our office, the Office of Institutional Equity, and then appointed by the President. So that's a student case. In a staff case, you're going to get a staff hearing board committee. That committee is selected by the Vice President of Human Relations. And if it's a case where there's a staff member respondent and a student complainant, then a student hearing board committee member is also going to be placed on that hearing board to kind of give voice to student concerns. And then similarly, as you might expect, if the respondent is a faculty member, there's a separate faculty hearing board whose membership is decided by the Faculty Affairs Subcommittee in the Faculty Senate. And so really, you've got the outside hearing officer who kind of runs the hearing, and then those 2 other panel members are, their identities depend on the identity of the respondent. But in the hearing, they get to review the investigative report. They get to hear from witnesses. You know, Mike alluded to the cross-examination requirement, that witnesses are brought in. If either parties have questions for them, if either parties have questions for the witnesses, their advisors will ask questions. Parties are not allowed to directly ask other witnesses or other parties questions. All of the parties' questions during the hearing will be asked through their advisors. But the hearing board itself may also have questions to, ask of various witnesses or parties. So that's the hearing. Even before you get to the hearing, there's a pre-hearing meeting where the advisors, the hearing officer, the parties, they're able to kind of work through some of the procedural issues. Obviously, you're kind of seeing the levels of complication to this. The pre-hearing meeting is an effort to simplify things as much as possible, to say, well, what issues are in dispute here? What witnesses do we need to hear from? How can we order those witnesses to make sure that they show up on time and are here and are excused from class, things like that. So the pre-hearing meeting is kind of this organizational step that the hearing officer and the parties and their advisors engage in. Both parties have the right to be present for the hearing and basically hear directly from not only the other party, but all of the witnesses. That said, the regulations provide, and Notre Dame has implemented procedures, if appropriate, where the parties do not have to be in the same physical room as each other. So because of potentially the trauma involved and seeing the other party, it can be arranged that, you know, the complainant is in one room with a video camera and a microphone, and the respondent is in another room with a video camera and a microphone. So again, that requirement that the parties can see each other and hear each other is met, but it doesn't necessarily need to be face to face. If the complainant or the respondent fails to attend the hearing will go on in that person's absence. And again, as Mike previewed for us, and as I've kind of explained a little bit here, by failing to appear at the hearing and submit yourself to cross-examination, the consequence of that is that party's statements that came in the investigation, or that party's written statements that were provided, that stuff is just not considered by the hearing board in its decision regarding responsibility. And again, that's a regulatory requirement that parties must agree to sit for cross-examination. So after the hearing, takes place, both parties have a right to an appeal. And the appeals are on relatively limited grounds. The chances for an appeal or the grounds for an appeal. So to state an adequate appellate argument, either the complainant or the respondent has to say there was a procedural irregularity that affected the outcome of the matter. In other words, in this long process that we've talked about with, I just kind of gave an overview here, but there are a lot of procedural hurdles that the university, that both parties have to make sure they're clearing. And if there was a procedural error that was so severe that it could have affected the outcome of the matter, that's an adequate grounds for an appeal. So the party would say, this was the error, and this is why it affected the appeal. I know I might be running out of time, so I'm going to try to go through the other appeal grounds a little faster. New evidence that was not previously available, that's another ground for an appeal. Conflict of interest or bias on the part of somebody in the process. So maybe the investigator, is the cousin of one of the complainants. Well, that's not really appropriate, and that person, the investigator, should have been recused. And so something like that, a clear conflict of interest or bias that was present and that affected the outcome. And then lastly, that the assigned sanction does not fall within the appropriate range of sanctions. All right, I think I got 2 more slides and then I'll try to wrap up. So, we've alluded to this idea that we've got regulatory procedures and we've got non-regulatory procedures. What we want to make clear is that if it's determined at any point that, hey, our initial assessment was off, we thought this was regulatory, but it actually, now that we learned what conduct, a little more specifics about the conduct that's being alleged, it's not actually regulatory. So there's an off-ramp. The university can move to the appropriate non-regulatory procedures. We're not going to cover that here. We're kind of focused on this Title IX regulatory procedures, but just know that if it's determined during the investigation or during the hearing that this is not an appropriate regulatory process, you can get off that highway. Similarly, if you're on another process and you realize, hey, this actually needs to be in the regulatory realm, you can get on the highway later on. And then lastly, Amber, if you want to move ahead, just a word about the standard of evidence. So the university uses the preponderance of the evidence standard. And what this really means is it more likely than not? Sometimes people say like 50.1% or 50% plus a feather. It's not the clear and convincing standard. It's not the beyond a reasonable doubt standard. Those are all kind of heightened standards that require even more proof to find somebody responsible for a policy violation. What the preponderance of the evidence standard means is it more likely than not that an event occurred? And so that's the lens, that's the scale through which the hearing board decides, well, what do we think happened? And based on what we think happened, was a policy violated? It's that kind of 50% plus 1 standard. I think implicit in that standard is the idea that the respondent is presumed not responsible. So the preponderance of the evidence means it is more likely than not. So you have to kind of meet that threshold that the respondent is presumed not responsible. Again, I think that's implicit in the standard, but it's also a regulatory requirement that it needs to be clearly stated that, in our American judicial system, it's innocent until proven guilty. And that's the same thing here. It's just the standard we're using to determine guilt, or in our terminology, responsibility, is the preponderance standard, not whether it's beyond a reasonable doubt. So with that, I'll turn it over to Amber.
Thanks, Pat. So in those previous information provided by Mike and Pat, they both alluded to alternative resolution. And I wanted to just take opportunity to unpack that a little bit more. When they're talking about the investigations, when they're talking about the preponderance of the information, those things are not utilized or necessary for alternative resolution. Alternative resolution does understand the harm, but we're not trying to determine whether or not there is a policy violation, if there's been a code of conduct violation. We're really identifying harms that somebody's reported and a respondent who is willing to say that even if it wasn't my intent, I contributed to these harms. And so I'm willing to make restitution and bring resolution to the situation. The really critical thing to understand about alternative resolution is that both parties must consent to participate in alternative resolution. And also that alternative resolution isn't always appropriate for every situation. And so we always have to vet whether or not this is an appropriate tool to respond to the reported harm. There has been in the past as well where mediation hasn't been allowed for sexual assaults, allegations of sexual assaults. And oftentimes people conflate mediation with alternative resolution. And so I just want to distinguish that to say that alternative resolution is more of that broad umbrella of alternative ways to address a concern that's brought forward. And mediation is a type of alternative resolution. But there are other types that I'll talk about. And so understanding that alternative resolution, the goal of it is to address allegations of harm that could be prohibitive conduct, right? And so when we're talking about that Title IX regulatory, as we indicated, you still have to have a formal complaint for alternative resolution under our sexual harassment regulatory policies. And so we would have understanding of the complaint. And so we do have to at least verify that it would be under the purview of that. But we're not looking for that preponderance of the information that Pat just talked about. We're really addressing the harm. And so the complainant has a lot of agency to say, these are the ways in which I've been harmed, and these are the things in which would be helpful for me to move past that. And then we would present that to the respondent as well, and he or she has the ability to negotiate. And there's different ways that we can facilitate alternative resolution. Again, I want to stress that it is voluntary, and that people can withdraw that consent at any time. Both Pat and Mike talked about the on-ramps and off-ramps, that we can go between different processes, and that is true even if we start with alternative resolution, or if we go to alternative resolution and for whatever reason people no longer they're not being satisfied with the direction or whatever, people can actually off-ramp again back into the formal process up until, really at any time up until there's a alternative resolution agreement. And then if somebody is in the regulatory process, they can jump into alternative resolution up until any time, even after the hearing, before a decision is made. So we do leave a lot of leeway. There's a lot of runway space to be able to go to meet the needs and to try to adjust to the agency of the participants. So again, when I talk about those types of resolutions, this is not meant to be a menu, but it is meant to be a springboard to help people discuss and talk about what's going to be helpful to them. Again, alternative resolution, we do it through a restorative justice lens, and so the hope is to bring resolution to the harm and the situation. Now, we do that with respect for both parties, because we want both parties to have a sense of being restored, but it is with the understanding that the respondent is willing to accept a certain level of responsibility, even if unintentional, of creating harm. And so there's some basic good faith assumptions that need to be there in order for alternative resolution to be effective. So again, when I mentioned mediation, it's not generally appropriate for sexual assaults, but certainly has been very effective for the multiple other kinds of harms that could be reported. When we talk about indirect mediation, that can also be called shuttle negotiations. And so that's generally where, I would go to, let's say, the complainant, and he or she would say, I would like you to ask the respondent X, Y, and Z, and would like them to do these things. And so I would go to the respondent, and he or she would say, X and Y is fine, but can we like alter Z in this way? And so then I would go back to the complainant to say like, hey, X and Y is good. These are and just, I would just do that kind of shuttle negotiation between the two. So they're not meeting together, and I'm being that intermediary to be able to help them come to a resolution. A restorative conference is generally where harmed parties and other people who are impacted by the respondent's behavior are invited to participate in what we can usually call a circle. And there's a facilitator that would, usually one or two facilitators that would help mediate that conversation. Now, before something like that happens, there's a lot of pre-meetings that occur. And so anyone that is going to be present at a restorative conference will have had usually 2 to 3 individual pre-meetings with the facilitator to understand the impact on them and their role. And again, the respondent, what his or her feelings are, and the complainant, what he or she experienced. And so the facilitator has a really in-depth understanding of the totality of the situation to try to help bring restitution and to that situation. An accountability conference is very similar, but it generally isn't necessarily people who are directly impacted by the behavior. So that wouldn't be necessarily direct participants, but what it could be surrogate representation. So for example, if the harmed party, like let's say the allegations are, let's say something non-Title IX to just be able to understand the concept of it. Like there's a party off campus, and like there's destruction and of people's property, and they keep people up at night and all of those kinds of things. We could have an accountability conference about that behavior, but the people that are in that might not be like these people's neighbor, but they could be somebody else's neighbor who's, like, hey, I had somebody who had a party next to me, and you kept my kids up, that kept my kids up all night. And so it's somebody who's had a similar experience, but not from that person, but it helps to give an understanding of what somebody might have gone through. It might also be people from the university. So even though this isn't a conduct process where there are outcomes because a preponderance of the information have been met, there could still be representation from the institution to say, like, this doesn't meet our values, or helping people understand, what we expect from our community. It could be other peers, for, let's say, a racial slur or something like that. So accountability conferences are very similar. It just uses different participants. So they might not be directly involved in that exact incident, but have investment in whatever that harm is for the greater community. So again, I want to say, to the point where you're tired of hearing it, that it is voluntary by both parties. They can withdraw consent at any time. It's intended to be remedies-based and an educational process. And so with that, I'm going to skip to that bottom point first and work my way back. Disciplinary outcomes, I used to say that they're not allowed, but that's not true. We would allow them, but they're highly unlikely because, again, both parties have to be in agreement of the outcomes, and it would be very rare for a respondent to agree to be dismissed from the institution based on alternative resolution or agree to have some kind of disciplinary outcome. That doesn't mean there's not outcomes. It just means that there's not disciplinary outcomes. And so if you look on the Community Standards website where it talks about student conduct, a disciplinary outcome is disciplinary probation, temporary dismissal with the ability to reapply, or permanent dismissal. Those are the things that are considered disciplinary outcomes. And as you might imagine, it's unlikely that a respondent would agree to those things as a result of alternative resolution. So it's important for complainants to understand that if you want to enter into alternative resolution and also want the person expelled, that those things don't align. And I, have conversations to help people understand that. So again, we always want to prevent, we want to stop, we want to prevent, and we want to bring remedy to any allegation of any kind of sexual harm on our campus, whether it be regulatory Title IX or otherwise. We want to address all harm and prevent all further behavior. So also within the alternative resolution process, we're allowing respondents to accept responsibility and be part of repairing the harm instead of assigning responsibility by a preponderance of the evidence. And again, the goal is to address allegations of harm and prohibitive conduct, but it's not based on preponderance, and we're not finding somebody in violation of an actual policy. So.
Hey, Amber, just want to chime in here quick. Thank you so much for all of this so far. We do want to make sure that we have time to get to questions. So I don't want to rush you too much, but if we can go ahead and get through these last few slides, then we can get to our Q&A portion. But thank you so much again.
Yeah, thank you. And so it should go more quickly. When we talk about sanctions, again, these are all outcomes that are available for any of our processes, whether it be regulatory, non-regulatory, alternative resolution. These are the sanctions or outcomes that are available and listed. Again, those student disciplinary actions on the far right there are less likely within alternative resolution. People have asked questions a lot about mandatory and responsible reporting. We did not change anything based on the new federal regulations, so it remained the same. And so for Notre Dame campus, as a reminder, it's essentially all faculty and staff, except those that are in University Counseling Center, University Health Services, and those that are professed religious within campus ministry. And to that point, most campuses function at a high level of mandatory and responsible reporting. Only 4% of institutional policies named a limited list of reporters, because the new federal regulations did allow campuses to give only a specific list of names who were mandatory and responsible reporters. Only 4% of institutions chose that route. And Notre Dame decided, with all of the other changes that were happening, that this worked for our campus, and that we did just continued as we were. Again, some of the ways in which our tri-campus communities collaborate. These are not all of the ways, but I think the ways that we are most involved with one another. There's an MOU on the title9.nd.edu website, and I'm assuming also on the other campus websites as well. It's a memorandum of understanding, which talks about how we handle cases involving various students, whether the respondent be from one of the other campuses, complainant, all of those pieces, in terms of, the expectation if you come to us and there's also other campuses involved. CSAP is the Committee on Sexual Assault Prevention. Many of us on this call, if not almost all of us on this call, sit on that committee, and it's a tri-campus committee. Take Back the Night is something that we've collaborated on for several years, and St. Mary's generally takes the lead on that. And so there is a website, Facebook page, I think, that Liz can provide the link to Meredith and Abby, and be on the lookout for further information if you've not already seen that. And then certainly the Family Justice Center, if you're not familiar with that community resource, it services all of our campus as well, and that is another confidential resource available within the community. And so with that, I will pass it on to a representative from St. Mary's.
Thank you. So Liz and I just have a couple things we wanted to make sure we talked about in regards to St. Mary's. I think it's important to know that St. Mary's also did not change who the mandatory reporters are for our campus. So for us as well, it is all faculty and staff, and then our residence life student staff as well. That's faculty and staff other than the confidential resources that Liz will talk about in a little bit. Reporting for St. Mary's, so any students that have access to their My St. Mary's portal, there is a reporting format there. Also, any emails to Title IX at St. Mary's is another way to report, and on our website as well. Our reporting process is very similar to the one that was outlined. Really for us, there is a decision that has to be made if we have jurisdiction over the respondent in the case. And if we do, then we kind of move forward with our the rest of our process. If not, then we really try to, as the coordinator and deputy coordinators, have at least a basic understanding of the processes of the schools of the tri-campus community. And so we try to talk students through that, and then we'll work with our students to file formal complaints at a different institution if necessary, if they'd like to. I think it's also important to note when we're speaking about St. Mary's process is that we have external investigators that we use for our process. So those are investigators that we hire outside, contract outside of the St. Mary's community that will kind of pull together all of that investigatory reports that were talked about earlier. St. Mary's also uses a preponderance of evidence. Yep, so I think that those are the big things. Again, like a lot of what we do seems to align very well. Terminology just seems to be a little bit different. And the processes do get a little complicated moreover. So those are kind of the biggest differences on our end. Liz?
Yeah, so I just want to reiterate who our confidential resources are on campus. These are individuals that are not mandated to report to the school if someone discloses to them that they have experienced an act of interpersonal violence, or if they're having other mental health concerns like suicidal ideation or anything like that. So the entire health and counseling staff, nurses, and counselors are all confidential resources. That includes myself. And then also certain members of our campus ministry staff, including Regina Wilson, Father Steve, and Liz Palmer. The three of them also serve as confidential resources on campus. So if you're feeling maybe as if you aren't sure if you want to report to Title IX or something like that, a confidential resource is a great place to start. They can help you kind of figure out what your options are and help you share your feelings in a confidential, private space before perhaps sharing that with other people on campus. But I also want to make sure all students know, and I'm sure this goes across our entire tri-campus community, that no matter who you report to, it's not going to be like spread in a mass email or go to 1 million people. It's only going to be on a need to know basis, and it's only going to move up. So for example, if you disclose to your RA that you have experienced a sexual assault, that will not be shared with other RAs. That will go to your hall director or to the director of residence life or to Title IX. It will only go up. So please know that whoever you choose to share this intimate information with, it will be kept as private as possible.
And I just wanted to add one other thing in regards to St. Mary's. We have new deputy Title IX coordinators as kind of our restructuring of our office. So they are Dr. James Gillespie, Nadia Ewing in the registrar's office, Adriana Petty in multicultural services, and Jennifer Wright in Disability Resources Office, and then Chris Urschel in Human Resources. So again, they're all people that you could reach out to as well in terms of reporting. And they'll all kind of get to our office and we'll go from there.
Hi, everyone. Maybe just a couple quick comments about Holy Cross College. I know we want to get to those question and answers. The only thing I would say, I mean, what a thorough presentation on process and the policies. So just to add to maybe even what was coming out of the St. Mary's kind of comments, how much our hall staff spends kind of understanding this process. And because, with not that everything takes place in the dorms, or that not that everything is contained with students on campus, but that is a significant portion of our student body and our student population. And there is a lot of discussions and sharing that goes on. And the RAs and the hall staff, our hall directors, are in a position to receive information and then know what to do with that in an appropriate way, to move things up the process. So again, an RA reporting something can't immediately make it a formal complaint, but it allows that opportunity for up the chain, a conversation to take place to a student that may be in need and needs to have the space to have that conversation and share, so that an appropriate process can take place. So I think that's important for students to know and to be aware of that, and in some sense be encouraged and supported by that, because the reality of the hall staff and interactions in the dorms often being kind of one of the main ways that information is shared, concerns are shared, and one of the main ways that students often receive help.
And with that, I will stop sharing my screen so I can see everyone as well. And Meredith and Abby, however you want to facilitate the Q&A.
Yeah, sounds great. And we just want to say thank you to all of you who were able to come out and be on our panel, to Amber, Mike, and Pat for that presentation. I thought that was great and really insightful. And to our members from St. Mary's and Holy Cross, we really appreciate you being here. I will say, as we're getting to the Q&A, we did receive quite a few questions. So say what you need to say, but also try to be concise, because we really want to be able to get as many questions in for students who submitted them as possible. So to get started, our first question is, how does Title IX apply across campuses? For example, if a St. Mary's student is assaulted by a Notre Dame student, will they still be able to report and get fair treatment throughout the process? Who do you report to if the person who harmed you goes to a different school in the tri-campus community?
So I'll take that one simply because the example given is a Notre Dame respondent. And so the respondent is really what dictates whose process is used. And so if that was a Notre Dame complainant and a Holy Cross respondent, then Andrew's process is what would facilitate that. And so, and that's where that MOU that I talked about, that memorandum of understanding, that's where that comes in, because that is what informs and guides how we share information within the tri-campus community. So you can review that, and that answers a lot of those questions. And certainly time beyond this, we would make ourselves available to clarify anything regarding the MOU.
That being said, I'd just like to remind students that if they want to report, just find someone you trust and report it. We all work very closely together. We will get your report where it needs to go. So I know this was a ton of information tonight, so if you forget anything, just get a hold of your own Title IX coordinator or someone else on your campus, and we'll make sure that that report gets taken care of.
Awesome, thank you. Our next question is, will cases not regulated under Title IX follow all of the new due process procedural requirements, especially the right to cross-examination and the rules related to it? Also, does Title IX regulation require that the complainant, respondent, and witnesses be the ones directly responding to cross-examination, or do their advisors participate in
I can take that one. So the first question was, does all conduct fall under these new Title IX procedures? And the answer there is no, that if it's not this, I think Mike classified it as a narrow definition of Title IX regulatory behavior, that if it doesn't meet that standard, it'll go through what we call our non-regulatory process. It's I think it's section 5B. If you're really into going in and reading the procedure document, 5B in our procedures. One clarification there is that it's the type of conduct that matters about or that determines what process you use, not where the conduct occurred. So we talked about whether conduct occurred off campus or whether it occurred in study abroad. There's some narrow limitations for when Title IX applies to that conduct. And frankly, Title IX says it doesn't apply if it's study abroad, for instance. But the way that at least Notre Dame has done it, and I think Holy Cross and St. Mary's are the same on this, is that if the type of conduct meets the regulatory Title IX definition, then we're going to use the regulatory Title IX process. So if it's a sexual assault that occurs, but it happens off campus or it happens in a study abroad program, we'll use the regulatory process to address that. The second question was, cross-examination. So are advisors involved in that process? Yes and no. So advisors are the only people, aside from the hearing board, are the only people that can ask questions. So a party cannot ask another party a question, but the party has to speak for himself or herself. So in asking questions, it's the advisor, but in answering questions, it has to be the party.
Got it. Thank you. And then just a quick follow-up. So when you talk about the regulatory versus non-regulatory, do both of those involve cross-examination?
Good question. No, the non-regulatory does not have cross-examination associated with it.
All right, thanks so much, Pat. For our next question, this is about alternative resolution. So the question is, can alternative resolution be pursued after the respondent is not found responsible? And could the Title IX coordinator file a regulatory report as a result of information that came out during the process of alternative resolution?
And Pat and Mike or anyone else, feel free to clarify if I misspeak. But no, so once a resolution is formalized, whether that be alternative resolution or our sexual harassment procedures, our administrative resolution, once those are finalized, so a determination has been made, then that is in fact the final. So it's not an actual term within our process, but you may have heard of like double jeopardy or so to speak. So we can't put you through this process and then if you don't like that one, we'll put you through this. And so that's why when I was talking about that earlier, I tried to be clear and distinguish that there are these off ramps, but that does end at some point, and that's when either an alternative resolution has been reached, and both parties have agreed and kind of signed off on the resolution, or if it's in the other process that the hearing board has given a determination. So after one of those two things have happened, then that is the final outcome, other than like maybe an appeal or something. But in terms of being able to choose what process, those are what conclude that.
Thank you. Our next question is, what do you do to protect survivors who report? What can be done for survivors who were perhaps in the same classes or on the same team as the person who harmed them?
Liz, do you want to take that? And then I will follow up you're an expert in that area as well.
Yeah, so what can be done to protect survivors? Of course, and I know when you report to Title IX, they're also going to provide you with other resources to kind of help you through this entire process. So if you're interested in counseling services or advocacy services like the ones provided in my office, those are made available to you and they'll connect you with those people. That's a great way to begin to start to support and protect the survivors through this process that can be really difficult. As far as if people are on, in the same classes or on the same teams or in the same clubs as that alleged perpetrator, there are regulations in place that allow the school to be able to protect you and make sure that you don't have to be in the same room as them. And I know that Amber can expand upon that.
Yeah, and we call them supportive measures, other terms are interim measures, those kinds of things. And so there's a certain level of response that we can have in between when a report is filed and the complainant is still determining their options. But it does limit what we're able to do in terms of, we can't impose or restrict things on the respondent without that due process. So banning somebody from participation in a student organization is more of an outcome than an interim measure. If there is something that's so egregious that emergency action needs to be taken, the regulations have really enhanced that process as well, in terms of there needs to be a hearing and all of these things before we can even take emergency action. And so we are limited in that sense in terms of imposing things on the respondent. With that said, however, we manage a lot of these situations simply through interim measure no contact orders. That's often all that the complainant wishes. And again, it often has the greatest impact with the lowest intervention, right? So, and so that can often satisfy. Within our process, a complainant has up to 6 months to decide what he or she might want to pursue, if anything. So they might want to get counseling for a little bit before entering into our process, or just want some space to maybe finish their exams or something like that, or do a variety of other things. And so they do have up to 6 months to decide and choose whether or not they want to file a formal complaint. And so again, in that time, we can do no contact orders. We can like there have been situations where we've actually had a situation where all of our campuses had people and they were all part of the band. And so we had to navigate all of that, and, and they're traveling to, a bowl game or something like that. And so just navigating those things, or an athletic team. And so helping people, what does that look like when everyone may need to be in the same space? And so I generally am the person helping to coordinate those for our campus. And we can also help people develop safety plans, just whatever the might be needed in terms of an interim measure.
That sounds great. Thank you so much, Liz and Amber, for that. Our next question is, do either Title IX or Office of Institutional Equity investigations allow character witnesses to testify about either party during the hearing?
I can take a first stab at that one, and any of the experts on here can weigh in too. We don't rule out a witness just because they are a character witness. The hearing board will ultimately decide whether or not evidence is relevant. And one of the things that can affect relevance is whether it's duplicative. So I don't think, a hearing officer or a hearing board is going to want to hear a person's entire, floor or dorm to say, I knew this person and he or she was a great person and, we all got along. That kind of evidence, at a certain point, it just kind of becomes duplicative and irrelevant. But that's not to say that all character evidence is per se irrelevant or won't be relied upon. It honestly is probably somewhat fact specific and case specific, but I don't think there's a categorical rule that character evidence would be considered in all terms or would not be allowed.
Thank you for that.
And that will feel very different from previous processes, right? So just that is a change that we wanted to know.
Thank you. Our next question is, can you tell us how many sexual assault cases have been reported this year? What are you doing about open cases, and why might it take the universities a long time to respond to them?
Well, again, so the question is making some assumptions that may or may not be true in terms of a long time, like we try to conclude within, so our process says that we try to conclude within 60 days, but obviously all of those types of things that Pat mentioned earlier in terms of availability of scheduling and those pieces, we just try to keep people informed as to where we are within a process. And then additionally, when we're on any kind of break, you know, when the university is shut down, so the entire time that students had off in between semesters, that actually didn't count towards an investigatory timeline, right? And so it can feel, I don't want to try to sugarcoat it in any way. The process is hard to walk through. It's arduous. It's some of that is the making of the regulations, and we do our very best. I mean, our investigators are extremely efficient, you know, and we're dealing with a lot of humans that have dynamic lives. And so as much as, you know, Pat walked through those steps, you know, it just doesn't always go as quickly or smoothly. And so, but we do try to keep people informed where we're at. They can request updates. Certainly what we didn't talk about that also is a factor is if a case is also possibly being investigated criminally, if NDPD or SBSVU has it, the prosecutor might say to us, like, we need you to halt your investigation. You know, we'll make notice of that, but that could pause our investigation as well. And so there's lots of factors that, you know, as an outsider looking in, you might have these perceptions that, you know, it took this long, but there's all of these other factors that oftentimes are outside of our control. Certainly when they're within our control, we're going to evaluate that and try to be as efficient and thorough as possible. And those things aren't always aligned with doing quickly, right? So.
And also, I would just say the only thing I would add is a lot of cases may go on for a long time, also because there's a lot to investigate. You know, Patrick and I have realized that it's not just a piece of paper, it's not just a folder, and everyone on this panel, it's actual people's lives. And in order for this, whatever the outcome is going to have a significant impact on everyone's lives. So the people that are investigating it want to make sure that we've got everything, have done everything to the best of our ability, and really searched under every rock to make sure that all the information is available in which to make an informed decision. So yes, that can be long, and but if it's short, then you're shorting the facts and information, and it's just the process breaks down because of it, unfortunately.
All right, thank you everyone for that. Our next question is, so I know that you all mentioned that you don't want students to be afraid of getting in trouble for drinking or varietals if they were to report an incident. Has this been applied to COVID rules as well? Will students not get in trouble for breaking COVID rules or the campus compact if they were to report an incident where obviously they were within 6 feet of another person or at a party, something like that? Can you elaborate a little bit more there?
Yeah, I mean, we didn't enfold that, like put it in print, but I can't think of any case where we wouldn't provide amnesty for that. Yeah, there's just no reason why we wouldn't.
Thank you. So our next question is, the new cross-examination requirements sound concerning. How are you protecting students' mental health throughout that process?
I can speak to one procedural issue that we have in place that I kind of alluded to before, and I think Amber or I'm guessing Amber because she's knowledgeable about everything, but she might be able to speak to some of the support resources that are available to students who are in our processes. But the more procedural device that we have available is this idea that you don't have to be in the same room as the other party, and the university will go to kind of great lengths to set up the hearing in a way, physically set up the space in a way that minimizes the impact of the cross-examination requirement. And I mean, I think everybody on this call realizes the cross-examination requirement comes from the regulations. This was not something that any of our colleges set out to implement. It's a requirement that has been kind of forced upon us. And so we're trying to make the best of the situation that, the hand that we're dealt, so to speak. But in terms of, how the hearing is set up, I think that physical or spatial limitation is one way, but then I know we do have other support resources that are available to both parties in our processes.
Yeah, and we talked about having an advisor and or an RC. People can, bring a support person with them, but that person can't be in the actual physical hearing. But they could be available. So let's say the hearing breaks, and so that person, could go get a hug from their mother or whatever that might be, or have their RC there for additional moral support or whomever they would want. It's just who can actually be in that physical space as the hearing is taking place at any given time within our process, whether it be a meeting with me or an investigator or at the hearing. A person is allowed one support person. And it's of their choosing. We do have advisors that we will assign to them free of charge, but people can also elect to have whomever they would like. But again, they can have a whole army of people physically available to them, but only one person in that space at a time during that process.
The one thing that I'll add is Pat talked about at the pre-hearing meeting. We hope, and I think the hearing panel members also try and use that as a way to try to address and try to agree to as many points as possible to stipulate to facts, so that hopefully the need for cross-examination is greatly lessened. So that's a way that both parties and their advisors can work out things beforehand, which helps, we hope, decrease the adversity of the actual hearing itself.
Thank you, everyone. Our next question, and I think we're going to try to get through 2 more questions in our time here, and then we'll wrap it up. Our next question is actually specifically about the slideshow. I think, Pat, you may have gone over this. Can you elaborate more about the point about considering hookup culture? And does the Office of Institutional Equity believe that consent can be taken back at any point in time?
I'm not sure I alluded to the hookup culture side, but I'll try to just speak to the, I'll try to answer the question. And yes, the idea of consent is it needs to be given at all times, and it can be revoked. And so, like I said, I don't think at least I didn't mean to use the term hookup culture or specifically speak to that concept, but in terms of consent, it is something that can be revoked, and both parties need to be fully consenting to all forms of activity. Consent to one form of activity does not mean consent to all forms that follow. And so, if there's one thing that we can really stress is the importance of, both parties being on the same page. And even if it's awkward to, have those conversations with people that you're romantically involved with, just to make sure that both parties are fully consenting to all forms of activity.
Thank you.
I was the one that said hookup culture, that discussed hookup culture briefly. I didn't mean to confuse anything in regards to consent. What Pat said is exactly correct. The only reason I brought it up is just for my purposes as an investigator, it often means that this conduct is occurring in more social places And so that leads to more witnesses and more individuals who I'm having to speak with, because it often happens at parties and that type of thing. But I did not mean to address consent in any way.
Thank you for clarifying that. So our final question is, what happens after you report to a mandatory reporter? Do you have to then cooperate with the university, and can you tell them to stop investigating?
So you don't have to communicate with us. What happens when a mandatory reporter provides a report to us, I'm generally the person that would outreach to the named harm party just to say, I've received limited information that indicates your personal safety may have been compromised or violated or whatever, and I invite you to come talk to me, and that you can have a support person. You're not obligated to do this. I outreach a couple of times, and beyond that, I don't want them to feel harassed by our office, right? So know that they're not obligated. And so again, it goes back to, again, the only two people that can file a formal complaint in terms of an investigation are the complainant or the Title IX coordinator. So a third party couldn't do that on their behalf. So let's say somebody did want to meet with me, filed a formal complaint, and then wanted to stop the investigation, they can certainly make that request in writing, and then it would be vetted. The Title IX coordinator would be the person that would vet that request, but we would also have to take into consideration that we've already started a due process for the respondent, and have to consider the effects of that as well. And so that request can be made, and then those determinations would be made by the Title IX coordinator.
Alrighty, thanks so much for that. And before we close out here, I just want to give any of our panelists an opportunity if you have any last or closing comments.
If you take nothing else from what we've said, if you see something, just say something. All the procedures don't mean a thing. Just talk to someone, and the resources will be used to explain to you your options and your choices. And all of us are in this for a reason, to help. And so never feel afraid to just say something.
All right, thank you so much. And we want to thank everyone again. To all of our panelists, we really appreciate your participation in this. We think this is really informative. We really appreciate it. And to everyone who's able to watch at home. And so thank you so much, and we hope you all have a great night.
Thank you.
Thank you.